May I please, my lord?
Yes.
My lord, I beg to mention item number 13, my lord.
This is in order.
Yes, my lord. My lord, I have been informed that, my lord, this is for framing of issues, my lord. But then I have been informed that Mr. Bindu Picha,
Second appeal.
yes, he is unwell, my lord. He's out of station on account of his health. Mr. Picha.
Why?
He is out of station, my lord.
Yes, yes. When do you want to say? How much?
2 weeks, my lord.
The petitioner, the appellant.
Yes.
Mr. Ojing Pada, Lana Counsel for the respondent submits that the Lana Counsel for the petitioner, Mr. T. Ikara, he is out of station and he requested him to take adjournment for of the matter for the day and to be listed after 2 weeks.
My lord.
Is great for come list this matter after 2 weeks. Okay.
Lords, I recommend item number 4, 25 and 14. Here the petitioner of the main counsel is same, A.K. Prakash.
One by one, please.
Item number 4.
4.
Yes.
Seeking adjournment.
Yes.
For the petitioner.
Yes, Lord.
Have you informed the other side?
Yes, they are already concerned.
Other side is present.
Not item 4.
Item number 4.
I am for item 25, Lordship.
25.
Item 4.
No.
So item 4, have you informed the
Yeah, they are already concerned.
item 4? Miss D. The answer for the other side. Praise for adjournment for how much?
After 3 weeks.
Praise for distinguished matter after 3 weeks. Prayer allowed. List this matter after 3 weeks. The interim order pass earlier shall continue till the next date of listing. Then which item?
Item number 25.
You said 14 also?
Yes, 14 also.
May I, Your Lordship? Your Lordship, I am on behalf of Ketama. He has been appointed as an amicus in this case.
Okay, and item 14?
Yes, for respondent number 2.
Okay, you have any objection?
No.
Okay, then here also.
May I, Your Lordship? Your Lordship, since TCR has been received, this matter may be fixed for admission.
Okay. Okay. Then wait for some time. Okay, we'll allow your adjournment prayer, but let us see TCR received what else. Okay. 14, wait for some time. And 20?
Item number 25.
25.
25.
Here you are for? Item 25. You are
Item
5.
number 25. 25, Lordship.
You are for?
I'm for petitioner only.
You are for the respondent.
Yes, Lordship. Lordship, here they have obtained the interim order. They are challenging the FIR and the allegation are also very serious. 376.
This is criminal petition.
Yes. They are challenging the FIR on merit only, but
On merit.
on every occasion matter was listed for hearing, but senior counsel they are not FIR. They took time on different occasion also. So Lordship, today also
Stay of the proceedings.
yes,
What is the offense involved?
376.
376.
Yes.
Then interim will be vacated.
No, Lordship. Actually, Lordship, leading counsel is in medical admitted, so very serious.
Who is leading counsel?
A.K. Prakash. So they have sent me the medical certificate also.
Last chance can be given one.
Last chance with the observation, Lordship, on next day.
Mr. D. Rilong submits that the leading counsel for the petition of Mr. A.K. Prakash has been hospitalized. Therefore, pray for adjournment of the matter. Mr. K. Loren, counsel for the respondent, submits that
Lordship, in here also entry may be continued.
Non-counsel for the Mr. K. Lord and non-counsel for the respondent shown some urgency as there is an interior in view of the above. That's the matter. In view of the above, the petitioner is given one last chance. Accordingly, the matter is adjourned. List this matter after 3 weeks. Para,
Fix date.
the interim order passed earlier shall continue till the next date of listing. Okay.
Also, may I pray for fixed date because
Fixed date.
the
Okay, they would like.
council board of petitioner
Yes.
has to appear from Guwahati. It will be convenient for him also.
Yes, yes.
Fixed date.
So fixed date,
After
After 3 weeks, on,
leave it. Okay.
11,
11? Okay, 18, 18 August. As prayed for by the land council for the party list this matter on 18 August. Okay. Yes.
Weekly order.
Mayor, my lord. I beg to mention item number 24. For 3 weeks adjournment.
May I, Your Lordship, I am for the petition in this case. And there is an interim also that may be continued.
No objection. Okay, you are for the respondent,
Yes.
Mr.
M. Tarak.
Land council for the your name is not there?
Still not, my lord.
Hmm?
No,
You are mentioning on behalf of
N. Tajay.
and appearing on behalf of Mr. N. Taji, land council for the respondent. Respondent number
2 and 3. Vote.
2 and 3, raised for adjournment of the matter. To which the land council, to which Mr.
J. Sri.
J. Sri land council appearing on behalf of the petition has no objection. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay. The interim order passed and shall continue till the next date of listing. Okay.
Your Lordship, I have another mention, that item number 2, with the concern of the other party, Your Lordship. Item number 2. This matter may be fixed after 3 weeks since Mr. K. Tama is not in the station.
Criminal revision. So
Item number 2.
you want adjournment?
Yes, Your Lordship.
Your name is also there?
I'm on behalf of K. Tama, Your Lordship.
So,
Yes, my lord, there is no any stay, so we don't have any objection. No stay is there.
yeah. Earlier also they sought for adjournment.
Yes, in many occasions, in fact, they have sought. In fact, your lordship, this the earlier coordinate bench has also heard this matter, but again they have taken time. So they,
I don't know why. They have, it appears they have a case.
it appears that they are trying to find out the case to protect their case.
I don't know why. For disposing of this matter. So they okay. Mr. Appearing on behalf of Mr. K. Tama, Land Council for the petitioner, prays for adjournment of the matter. Okay, so there is a private respondent. Have you informed?
Yes, Your Lordship, I've informed.
Okay. To which Mr. P. Okay. Lanet additional people has no objection. Mr. So-and-so. Father Sam Mr. P has also informed the Land Council for the private respondent. And has prayed for Kama. List this matter after 3 weeks. Okay.
Oblige, your lord.
Hello.
May it please lordship, I beg to mention one unlisted matter.
This is regarding,
Bail application upon the POCSO.
okay. Bail whether, okay, bail can be allowed by this court. Okay, yes.
Yes. May I, Lordship, I wish to mention item 23 for adjournment. Lordship, I on behalf of Mr. T. Tofu, due to health issue, leading counsel is out of station, Lordship.
So 23 is for order. Let us see for what for it has been listed. Okay, we'll grant adjournment, but wait for some time. Okay.
Okay.
Lordship, I beg to mention item number 16 and 17.
16 and 17. Wait for some time. We'll see the record. What for it has been listed. We'll grant adjournment if you're not ready, but wait for some time. Okay, we'll see the record first. Okay.
Lordship, I beg to mention item number 9. I on behalf of N. Sharma.
9.
Yes, Lordship. Lordship, the leading counsel in this matter has sought adjournment because of his ill health. Lordship. And Lordship, there is another matter between the parties, a CRP case.
Let us deal with this first. This is item 9.
Yes, Lordship.
Item 9, I think after filing. Now, who is for the, have you informed the other side? Yeah,
Yes,
the caveat
yes.
also, caveat.
Yes.
Have you
I have
informed?
informed the yes, other side. There's another CRP case number 76 of 25. So my prayer is that this matter may kindly be listed together with that CRP case, which is to be listed after 3 weeks.
The respondent you have informed.
Yes, Lordship.
Another matter is involved with, who is the petitioner in that another matter?
And it is between the same parties.
See, after filing,
It was filed by a local council here. The leading council is coming from out of station, Lordship.
this has been listed on mention. You want this matter to be listed after?
Listed with the CRP case numbers. There was for it to be listed after 3 weeks, which is possibly during August 11 or 12.
Okay. You're Mr.
A Gamre,
A.
Gamre,
Land Council for the Land Council. You are appearing on behalf of
behalf of N. Sharma, Niranjan Sharma.
Land Council, appearing on behalf of Mr. N. Sharma. Land Council for the appellant. With the consent of the Land Council for the other side. Praise for listing this matter after 3 weeks along with
CRP, CRP 76
CRP 76
of 2025.
2025. Prayer is allowed. List this matter after 3 weeks.
Bless.
Your Lordship, may I plead? Lordship, this is successive bail application filed on behalf of petitioner, wherein trial court reject the bail petition, citing that before examination of the alleged victim, the bail can't be granted, wherein the alleged accused is languishing in judicial custody for more than 85 days. So, my humble prayer before your honor, your lordship, is that under 164 CRPC and 161 was already recorded, and in it, the alleged victim girl has clearly cited that she herself went to Lakhimpur, Assam by herself, and that corroborated with that 164 and 161 statement, and the birth certificate of the alleged accused is also age only 20 years of age, where both of them are on love affair with one another. On this serious case, the alleged accused is languishing in jail for more than 85 days, and his bail is not considered, and cognizance was taken at 19th May 2025 by judicial. POCSO Act Section 35 is clearly mentioned that after taking cognizance, within a month, the trial court shall examine the victim, wherein my case, already after taking cognizance, it is almost more than 2 months, but yet, and next date is fixed after CC, next date is fixed on 12th of November 2025, which is almost,
After CC,
yeah, after CC, next date is fixed for examination of alleged victim girl, is fixed for November 12th, 2024.
so charge already framed.
Yeah, charge already framed.
Okay, then,
So,
so this is subsequent bail,
yes, this is succession. Yes, my lord. Successive bail.
So bail was rejected by the trial court.
Yeah.
And what is the new ground you have taken here?
Yeah.
What is the new ground you have taken?
New ground is that at the MLC report, there is no proof of any recent sexual intercourse between them at the alleged victim and alleged accused.
Let us see the bail rejection order.
Rejection order, my lordship, that is in Annexure 4, page number 26.
There is a possibility. Victim objected. In the case, victim has objection in granting bail to the accused person, and there is every possibility that in the event of release, he will hamper and tamper with the witnesses and threaten the victim.
My lord, where is he is in a jail and charge is already framed. There is no any chance of hampering and tampering of any evidence.
Victim has not yet been examined. That is why.
So, my lord, that
constant threatening. See,
my lord, in Section 35 of POCSO Act, here after taken
yes, Mr. Can call for.
Since matter has been charge sheeted and TCR will be called.
Mr. You are
Yeah.
Mr.
PM Lomdak.
PM
Lomdak.
Lomdak, Land Counsel for the petitioner. By filing this subsequent bail application under Section 483 of the BN Bharatiya Nagarika Suraksha Sanhita 2023 BNSS 2023. The petitioner is seeking release of the accused Mia Hussain Ali on bail, who has been arrested in connection with Itanagar WPS number 22 stroke 2025 under section 85 stroke 64 of BNS read with section 4 stroke 6 of POCSO Act 2012. Call for the scan, since the case has already been charged sheeted. Call for the scanned copy of the trial court record. Issue notice. Since Mr. T. Tado, G. Tado, line additional PP. Accepted notice on behalf of the state respondent, no formal notice need be issued to the said respondent. However, the petitioner shall take steps upon the private respondent number 2 entry by a registered post with AD, as well as by usual process within 2 days from today.
It should be through judicial police stations.
Okay, step to the respondent through the jurisdictional police station within 2 days from today. No? Within 2 days. Start, huh? Then to be listed. Where is this? Which court?
It's lawful.
Record is to be called from which court?
Yes, it can be. It's a WPS case, so it can be on Tuesday, next Tuesday.
Itanagar PS. Okay.
Next Tuesday.
GPR. Next week.
Next
Whether the notice will reach to the private respondent.
5th of August.
Okay. List this matter on 5th August. Okay.
Online.
I'm much obliged.
May I please, Your Honor.
Mr. PD Nair was supposed to appear through online.
Hmm?
PD Nair was supposed to appear through online matter. So due to some technical problem, I think so he could not appear also.
You were supposed to file affidavit in reply.
Yes, that we will file it.
Have you filed?
No, we will
Not
file
yet.
it. We'll file it.
You'll file.
We'll file it.
When?
Within a week, my lord.
Within a week.
Within a week, my lord.
Mr.
K. Bui, my lord.
Bui,
On behalf of Mr. Nair, PD Nair.
Lana Council, appearing on behalf of Mr.
PD Nair,
P.D. Nair,
my lord.
prays for and is granted for the 2 week.
My lord, if, may I ask for the date, my lord?
When?
If it could fix on 5th of September, my lord.
5th of September.
5th September, my lord.
Okay. For 4 weeks time to file affidavit in reply to which Miss
Yasmin Gao appearing on behalf of DSJ
yes,
M.
yeah,
Yasmin Gao
Hmm.
appearing on behalf of DSJ M. Kato.
Go appearing on behalf of
DSJ M. Kato for respondent number 1 and 3.
appearing on behalf of
DSJ M. Kato.
okay, M. Kato, Lana Council for the respondent has no objection. Prayer allowed. List is matter. The age prays for, comma, list is matter on
5th September, my lord.
5th September.
Right.
Miss Pango.
For the state, your lordship.
Pango, Learned advocate, learned government advocate appears on behalf of the state respondent. Okay.
Deeply obliged.
You have filed affidavit.
Yes, your lordship. We have filed, your lordship.
Okay, that's why they want to file reply. Okay. They want to file reply. Short for time, we have fixed the date. Okay.
Right.
5th September.
5th September.
Yes, yes.
Deeply obliged.
Yes, your lordship.
Item What happened to this? 5? Five, second adjournment. 5 was adjourned.
5 to 8 was after.
But this is, oh, that was connected with 5.
बोलेगा ना क्या बोलेगा
5 to 8.
Oh.
5 to 8. 5 to 8. I don't know.
This is item 8. 10 to 11. But here, 5 to 8 was represented by some other advocate. 9. Okay. Then that would be 5, 6, 7, 8, huh? The earlier was 10. These, huh? Not this, these matter. Okay, this is item
Instruction.
10 and 11. This is not 5 to 8. Which one is correct? 5 to 8.
number 12. 1, 5, 8,
Yes.
My lordship.
294. Is it correct one? Check. It's written 5 to 8. Yes.
Lordship, in item number 10, CRP 57 of 25, the petitioners herein are challenging the imping order passed by the learned Deputy Commissioner CME, page number 43.
Page
number 43, annexure 6.
Yes.
Lord, there are one more WPC writ petition pending before this, which is tagged with this, along with this, item number 11, Lordship.
5-1.
513, Lordship.
This is item 11.
Yes.
10 and okay, 10 and 11. Take with.
While,
yes.
yes, upon hearing the matter 513, the Honorable Court, this Honorable Court has passed the order dated 11/11/2024, Lordship.
In 513.
Yeah, in 513, Lordship. Order directing the respondent authority to dispose of the representation.
Okay. Yes.
That was the order in 513,
Yes,
Lordship. Now, while disposing of the representation pending before Deputy Commissioner CME this week, the
This
Deputy
impugn order
Commissioner
is-
has passed this impugn order, Lordship.
Okay. By this impugn order, the Deputy Commissioner has disposed of the representation submitted by the petitioner.
Yes.
Okay. What is
Lordship,
wrong in it?
how I am aggrieved by this impugn order is that the Lordship, the Deputy Commissioner has passed this order without authority of law, Lordship.
Okay.
The Lordship could find the order where I am aggrieved in last para, Lordship. In light of above circumstances, complying the Honorable Guwahati High Court so and so order dated so and so, the land acquisition process at Hayang Land, Tato Siyomi district, measuring so and so square meter is suspended and kept abeyance till the matter is amicably settled at appropriate forum. Lordship, while adjudicating the process, the pending representation, how the matter can be repaired as amicably settled? There cannot be any amicable settlement in the court of law, Lordship. So this order has been passed wrongly by Deputy Commissioner Lordship Simit. While dealing with the matter related to the compensation Lordship, land acquisition process, the Deputy Commissioner has to act as a District Collector Lordship, not as a Deputy Commissioner Lordship. The Act is very clear, Lara Act is very clear Lordship. And this order has been passed in capacity of Deputy Commissioner,
So it should have been by the
District Collector.
district collector.
Yes, Lordship.
Okay, so the district collector has a authority to dispose of the representation.
Yes, Lordship. While disposing of the representation, they have referred that matter is amicably settled. How, Lordship, judicial process there can be amicable settlement of the dispute, Lordship? He should have transferred any pending matters as per provisions of APCC 2021 Lordship. Transfer to civil court, Lordship.
Okay.
That is the correct process, Lordship. Under section 15 subclause 3 of civil pro.
As per
Arunachal Pradesh Civil
section
Code.
15.
Section 15.
Yes.
So therefore, I humbly pray that this order may be set aside.
Is that for the first time?
No, this
No.
is the second time, Lordship.
Second.
Earlier occasion also, Lordship has heard the matter.
I'm appearing for the matter.
Yes.
Private respondent in the citizen and my lord, the item 11 is the writ petition matter filed by me, my lord. My lord, kindly take up the writ petition matter in order to clarify the facts, my lord.
513.
Yes, my lord.
Yes.
Well, the writ petition has been filed with two prayers, my lord. Prayer page 35, my lord.
Yes. 35.
Page 35, my lord.
Yes.
Prayer number 1, my lord. Impure illegal public notice dated 8/10/2024 issued in respect of the disputed land of the petitioner measuring such and such square meters by the Deputy Governor COE District Support under section 21 of the Right to Fair Compensation and Transparency Land Acquisition Rehabilitation Resettlement Act 2013 for acquisition of the land measuring 50 hectares for Tato 1 HEP hectares for Hayward successor located at Tato and Rapung Circle of COE, wherein the land belongs to the petitioner and has been notified in the name of the private respondent in respect of the Hayang land measuring substances shall not be caused and second time. My lord, first prayer is, my lord, in a land acquisition proceeding, my lord, some part of the land, my lord, belongs to, my lord, us, my lord, the petitioners, my lord, has been, my lord, under section 21, my lord, notified in favor of, my lord, them, my lord. So, in section 21 proceeding, my lord, in a land acquisition proceeding, under right to fair. That, my lord, we have challenged in this writ petition, my lord, first part, my lord.
Okay.
And against that section 21 notice, we have filed a representation, my lord. And in the interim, my lord, it was directed to dispose of that writ petition in connection with the land acquisition proceeding, my lord. That was, my lord, disposed of, my lord, in the impugn order in the civil division petition. Second prayer is, my lord, kindly see, my lord, the impugn, arbitrary and illegal ex parte judgment and decision dated such as 7/10/1996 passed by executive message first class West Siang district COME, whereby land in dispute has been passed in favor of the respondent Rinya clan in gross violation of provisions of section 36. But the second aspect is, my lord, and my lord, a title conferred by executive magistrate first class, my lord, in favor of the, my lord, the petitioners in the civil division petition, my lord. There are two, my lord, challenges made in the writ petition. Now, my lord, the first for the first, my lord, subject matter, my lord, this honorable court has directed my lord to dispose of my representation, my lord. Accordingly, my lord, that was under the, my lord, right to fair act, my lord. That application has been made. That was disposed of, my lord, till the settlement of the, my lord, dispute, compensation, acquisition proceeding in respect of that land has been stayed, kept in abeyance, my lord. That he has challenged, my lord. Now, my lord, the second part of the writ petition, I have the instruction, my lord, telephonically, my lord. The pending appeal before the, my lord, DC has been transferred to the civil court, my lord, now, my lord.
That means after disposal
Yes, my lord.
of the representation.
Yes, my lord.
So
That is a different aspect, my lord.
that is different.
That,
That is not because that has been kept in abeyance.
Yes.
That is still there.
yes, my lord. And second prayer was also, my lord, disposal acted upon by the deputy commissioner, my lord, by transferring the, my lord, appeal pending before the DC to the civil court, my lord.
Already transferred.
Yes, my lord. Everything in, my lord, became infractors, my lord.
So this writ petition is infractions.
Yes, my lord. And, my lord,
But then since the disposal of the representation, he is agreed by the disposal of the representation. So that still is there.
yeah,
That will also become infraction.
That will-
My
If it is
instructions-
transferred, if it has already
Yes,
been
ma'am.
transferred.
Yes, madam. My instructions, I have received instructions. In item 11. What it says?
This is in item 11.
Yes, madam.
Okay.
It belongs, it is regarding the same lane. Same
Okay.
lane, both parties are disputing.
Okay.
The Hayang Lane Award was prepared and notice to all individual property owners were issued. Also displayed the individual award statement on 12/5/2025 for inspection. Those cases which were under complaint and counter complaints award were not handed over. However, they were allowed to inspect the amount of award. During the land acquisition process, both the parties have not objected against the land acquisition for the project. In the later stage, that is on 14/10/2024, applications was received from Sri Malin Koje and others claiming ownership of the said land and claims that the property assessment should be made in their name. Till at that point of time, no complaint was received from both the party objecting regarding process of land acquisition. Thus, acquisition process continued and finalized the value of land and standing trees for payment of compensation. However, whosoever is entitled to be paid. While preparing the final award, the records of both the parties' claims and counterclaims were recorded. Payments shall be disbursed as and when the clear title over the property is settled among them or through any competent authority. Notice under section 32 of the LARA Act was displayed on 12/5/2025 in the office board, but have not been issued to any party as the land seems to be under dispute. They were only allowed to inspect the amount awarded for the payment of compensation against the land acquired. The appeal under appeal dated 20/11/1996 has been transferred to the district and district judge judicial magistrate West Siang district Alo by number so and so dated 18/6/2025. Now, in the second page, my lord, that while this has been transferred to the civil judge.
Just a minute. The appeal dated 21/11. This was passed in this appeal.
Yes, that has been
is not in
transferred.
57, not in CRP 57.
No, no.
The which
No.
was disposed of. No, this is not the.
This is a
not the
long
one.
pending appeal.
Okay. So
Long
if-
pending appeal that
Okay,
that
different.
my lord will be clear from the next page of the instruction. If my lord will kindly see.
Okay.
This is to address to
Okay,
the
513.
civil judge senior division.
Hmm.
Transfer of case there between so and so. In the matter of above mentioned case, it is to submit before you that as per Arunachal Pradesh civil codes, the pending cases before the office of the DC so and so has to be transferred to the court of civil judge, junior division, civil judge, senior division, additional district judge as per the territorial and pecuniary jurisdiction. Thereby transfer the above case. The brief gist of the case is as follows. In 1995, a land dispute arose between Rinya clan and Koje and Rida clans regarding Hayang land Tato. The village authority decision dated 1996 was in favor of Rinya clan, and thereby Koje and Rida clans were the aggrieved party. The aggrieved party, Koje and Rida clans, appealed against the decision of the village authority in the office of the Deputy Commissioner Alo, West Siang District. The office of the Deputy Commissioner Alo, West Siang District, after examining the jurisdiction of the case, instant case was made over, committed to the additional Deputy Commissioner Mechuka for trial and dispose of appeal case filed by Rida and Kojak clans, white number so and so, dated 2/10/1996. On receipt of the instant case, Sri so and so, the then ESC Mechuka heard the matter at length and pronounced a decision in favor of Rinya clan in the capacity of Executive Magistrate First Class on 7 October 1996. On 20 November 1996, the Sri Tako Koje and Lipo Rida, on behalf of Koje and Rida clan, filed an appeal petition before the office of Deputy Commissioner Alo against judgment given by Sri so-and-so ESC Executive Magistrate First Class. On 27 November 1996, Deputy Commissioner Alo, white number so-and-so, made over the case to additional Deputy Commissioner Mechuka for the second time to hear the appeal petition of Sri Tako Kaje against the judgment of Sri so-and-so ESC Executive Magistrate First Class. Since then, the appeal petition filed by Rida and Koje is lying pending technically and officially in the office of the additional Deputy Commissioner Mechuka. Subsequently, in the dispute over Hayang land measuring so-and-so square meters between Rinya and Koje Rida clans, the Koje and Rida clans filed a petition before the Honorable High Court for injunction to suspend acquisition and assessment process for Tato so-and-so. The Honorable Guwahati High Court Itanagar Permanent Bench Itanagar considered the petition of the petitioner dated so-and-so and directed the Deputy Commissioner Siyombi District to consider and dispose of the petition dated so-and-so. In pursuant to the Guwahati High Court injunction order dated so-and-so to consider the petition of the petitioner categorically, the Deputy Commissioner Siyombi District suspended the acquisition and assessment at Hayang Land Tato Siyomi District, measuring so-and-so, and kept in advance till amicable settlement of the dispute at appropriate forum. Under such circumstances, the matter needs to be heard to decide the title of the land measuring so-and-so at Hayang Tato land. Therefore, the instant case is hereby transferred to your Honorable Court for trial and dispose of the title. So now it's both this CRP and the repetition. It is for payment of compensation, it seems, the main motive. But so long as the title is not decided, that has to be first decided. So this agitating here in this High Court will not suffice now. They will have to pursue their case before the...
Subsequently, the case has been transferred to the civil judge for decision of the title. But unless, of course, the title is decided, it will be difficult to pay. Whom to pay?
No, Lordship.
So
Lordship, for clarity of this Honorable Court, since the title has been decided and declared in favor of the present petitioner in the year 1996, that judgment is not interfered by any court of law till that person. So when there is no any interference of the judgment rendered in favor of me by any court,
executive,
ESC. Yes, Lordship.
Title was decided by ESC.
ESC, Lordship. So title is in my favor, Lordship. So under
that is not under challenge according to you.
That is not under challenge, Lordship. And that is not being interpreted by any court of law, Lordship. No judicial order is restrained that judgment.
So according to you, the decision of the ESC deciding the title of the land in your favor,
yes, Lordship,
attain finality, and therefore the compensation
yes,
will be paid to you.
Yes, the respondent need to challenge that judgment first, Lordship, to establish their ownership over that land, Lordship. Unless that judgment is interpreted by any court of law, then how mere submission of representation would suffice the claim of the respondent? Since that is the judgment of the executive magistrate, Lordship.
Now,
can that judgment be override by mere submission of representation, Lordship? The judgment rendered by the judicial authority can be override by the mere submission of representation, Lordship. That is the mere question, moot question over before this honorable court.
Now, the submission of representation is in the, not in the form of appeal before the deputy commissioner.
Yes, Lordship.
Appeal against that, not against appeal, not the, not an appeal, in the
Yes.
form of an appeal
Yes, Lordship.
against the order passed by the EAC to the deputy.
Yes, Lordship.
Was it or was it not?
Lordship, they have filed an appeal before Deputy Commissioner RO, as well West Siang District, Lordship. And now that appeal has been said to transfer to the ADC Mechuka. Now ADC Mechuka comes under the Deputy Commissioner COME since district has been bifurcated, Lordship. Now that appeal is said to have pending before the Deputy Commissioner COME Tato, and now they are saying that the pending appeal is being transferred to the civil court. Now, that is not my case, Lordship, here. What my case is that during the acquisition of land in question, there was a judgment in favor of me. Then how this representation can suffice and override the judgment rendered by the judicial authority in favor of me? Unless that judgment is being interpreted by any judicial order, how Deputy Commissioner and District Collector can say that this is under dispute? Since the judgment 1996 is in my favor, that has to be challenged by the respondent. That is not being done by the respondent. Or even if the appeal is pending,
by this order, it seems the case has already been transferred.
yes, Lordship, that is there.
Civil judge, because the impugn order which you have challenged by the CRP is no longer with the deputy commissioner.
Yes, Lordship.
Deputy commissioner thereafter subsequently has already transferred it to the civil judge, civil
Yes,
court.
Lordship. That is there, Lordship.
Now, what will be the position according to you?
In that case, Lordship, I have a prayer before this honorable court. Even if the pending appeal is transferred to the civil court, in that case, my respectful prayer before this honorable court is to suspend, to restrain the deputy commissioner to mutate my land in favor of the power proponent. To mutation process shall be.
Unless you appear, unless you apply for mutation.
Lordship, mutation, generally mutation is done by the deputy district collector, Lordship, in favor of the project proponent, Lordship. So when my case is pending before the competent authority, the competent civil court, then my land should not be mutated and my land should not be transferred to the project proponent unless dispute is decided. This is my respectful prayer before this one.
Correctly submitting my thought. That tendency of the proceeding the in the ownership of the land is pending now with the civil court matter.
Yes.
What he prays that whether deputy owner should not mutate the land in favor of the.
Oh, should not.
Yes, should not.
Okay.
This order passed by the deputy owner in the impugn order matter. The acquisition committee has, in respect of the land, has looked at in a various manner. Mission of mutating in favor of the NSPC doesn't arise matter. And kindly, again, whether Feroz Shah matter, impugn order matter, that it was kept in abeyance matter, the proceeding order matter. Case 43 of the civil proceeding matter. Which he has taken number, case 43. In light of circumstances, contract the honorable body airport order number 47 cases, level equals for the lane acquisition process at higher land, therefore, this will be very suspended and kept in against still and necessary. So, when a question of mutating in favor of the report, doesn't arise my lord.
Yes. So that means if your submission is that, then it is in your favor.
No, Lordship, in order, it is admittedly reflected, but however, it is the ground reality is different from this order.
How would you understand?
Lordship, that is there, Lordship. Otherwise, Lordship, in my second prayer is that, Lordship, till the pendency of that appeal, any kind of activities over the truth land and disputed land may be restrained.
Now, it is already kept
No,
in abeyance.
Lordship, this observation may kindly be made. Otherwise, the ground in the activities in the ground level is completely different. Lordship.
My lord, they have not objected to the acquisition process, my lord. First of all, none of the parties, either this revision petitioner or the writ petitioner, none, they are ready for the acquisition of the land. Now the dispute is only with regard to the award who has to be paid. Now at this stage, the authorities are ready to pay, provided who is the actual owner. Now, because of the infighting between these two people, why the developmental process should be kept at hold?
Otherwise, this
They have not objected to
already
the
sta-
acquisition process.
already begun. Otherwise,
Yes, they have not
now
objected
after
to-
this order, what happened? After this, the deputy commissioner's order, what happened?
no, that matter has been transferred. Now only the part for payment of compensation is remaining. That if both the parties, whoever is entitled to, if that is decided, the authority is ready. How they have not objected to the initial acquisition process, neither of this party. Now, just because there is a dispute, they don't want the developmental activities to be carried forward. My lord, that observation may not be given. It is for the interest of the larger public. Everyone, they have not objected to the acquisition. There is a categorical statement here.
Yeah, after acquiring, or whether the work has started or not? Not yet.
No, work is started, Lordship, undergoing work.
Okay, then
Work is under- Lordship, I have been to there recently.
Work is
23rd
undergoing.
of this month, I have been to there.
work is
Work is has already started. Lordship.
already
Work-
started.
work-
yes.
It's in the process.
Yes.
Then it will be difficult to stay.
No, Lordship,
Because since
the what?
they are ready to pay the compensation, it's only the party who is to decide whom to pay.
Lordship, what learned AAG is submitting is absolutely correct, Lordship. I'm not disputing that fact, Lordship. Lordship, however, there are some process under Lara Act, Lordship. Lara Act, what Lara Act says, Section 37 subclause 2 is a final individual award, Lordship. After that, the landowner would receive their reasonable amount, their awarded amount. Then after that only the Section 38 will come, Lordship. In Section 38, the land will transfer to the project proponent and they will have the possession over the land, Lordship. Now, when my amount is not being paid, how this Section 37 can be attracted against me, Lordship? That is the difficulty, Lordship. Unless my land is being adequately paid, there cannot be any possession, Lordship, over my land by the third party, Lordship.
My lord,
Let us, so that means the writ petition has become infractions. Okay, that's one by one. Okay, so we'll only say it has become infraction.
Yes.
Or
In view of the
transfer of the title
okay.
appeal.
kept in abeyance order and the transfer of the appeal.
Mr. In 11, huh? Mr. Intu Sokia, then counsel for the petitioner. Also heard. Are you in 11? You are not in 11?
No, actually, I'm not in 11.
Okay. Also heard. Mr. N. Ratham, then additional AG, appearing on behalf of the
Respondent number 1 and 2.
number 1 and 2. Mr. N. Ratham, then AG. This is presented by you only?
Yes.
Okay. Submit that. Your prayer is to transfer only, isn't it? Sorry, no?
First is matter to stay the matter. Section 21 of this matter.
where is the prayer to transfer? Prayer number?
Prayer number 2, my lord.
4.
2 or 4?
4. At page 37. Appeal dated 2011-19, which is still pending before the Deputy Commissioner Tato Sriyomi shall not be forwarded to the
Page?
competent. 37.
37. Prayer number 4. To direct the collector.
Wait. Already.
In fact, what is also my lord, and this sorry, my lord, in prayer to my lord, I have made it to my lord, 1996, my lord, my lord, conferred by the executive magistrate to the the opposite party. But this aspect can also be my lord decided by my lord.
Yeah.
It has been transferred by lord, because once an title is in my lord, right and title about the land has been passed by executive magistrate, does not have the jurisdiction to pass right and title of the land.
But you have not challenged, you have challenged.
Yes, it is paragraph 4.
Why did you have challenged?
Because my lord, the order passed by executive magistrate is a nullity matter. That can be challenged in any proceeding before any appropriate court.
Lordship, in that case, respondent counsel appearance would be required, Lordship. And reply would be affidavit. Otherwise, if this prayer is to be considered.
7/10/1996 is the executive magistrate.
Afterwards, my lord, the district already my lord transferred the matter to the civil court. My lord, I will take the plea before the in that appeal. My lord, may close the decision. It is still, I will not ask for the prayer number 2 matter.
Okay.
Because the appeal has already been transferred to civil court. In that, before the civil court, I will make myself.
Okay.
Okay, say yummy. My lord, in my instruction, this appeal which is sought to be set aside by his client, my lord, that appeal has been transferred, my lord.
Yes.
So if this is set aside, the transferred appeal will become infructuous.
No, it will not be set aside. He
Yes,
said that,
so-
that he is not pressing for that.
Yes.
So, the prayer for.
Okay, then the petitioner filed this writ petition. With the following prayer, okay, then you type the prayer, okay? Okay, then para, Mr. Nino Rathanson, Lanet, Additional AG. Submits that the civil revision. Where is the appeal? This is while disposing of the civil revision only. While disposing of the civil revision, this was transferred, isn't it?
No, my lord. While
No,
this
civil appeal. Kaba appeal.
Subject civil revision number. This is civil revision number.
This is the instruction in the civil revision,
Okay.
but it will cover the writ petition also.
Okay. Some is that the appeal. Where is the number?
Appeal dated in serial number 3 of the instruction, the appeal dated 2011-1996.
That's the appeal dated 2011-1996, filed by
The petitioners. Writ petition.
filed by the writ petitioner has already been transferred to the district and judge. It was to district and session judge or to the judicial?
No, to the civil judge senior division. In the next para, next page,
para.
next page.
But this,
But here they have mentioned district judge, judicial magistrate West Siam.
okay,
But
has already been transferred to the, where do we find that?
next page of the
Next page,
instruction.
para?
No, to address to the civil
Okay.
judge senior division.
Okay, has already been transferred to the civil judge senior division on 18 to
West Siam.
25. Huh? This is the only, okay, the rest of the claim then you are not pressing for. So this, if this, with the transfer of this appeal, so your prayer has been complied with.
Prayer number 1 is also complied with that.
Yes,
Prayer number 1.
okay, so Mr. Next para, Mr. R. Kelan, counsel for a petitioner established that with the transfer of the appeal filed by the writ petitioner, the prayer number 1 and 3.
4.
1 and 4 or 3, 4 have already been complied with, and he is not pressing for the prayer number. That is, which one was title you are challenged, which you are not pressing for you?
No, my lord, prayer number 2 and 3 will be subject to the outcome of this.
Okay. He is not pressing for the prayer number 3.
2 and 3 will be subject to outcome of the
illegal expert judgment and sorry, prayer number 2. Huh? Is
entry will be subject to outcome of the proceedings before the civil judge.
as the said prayer would be decided in the appeal transferred. No?
Yes, madam.
That will be decided.
Yes.
Okay. Okay. In the by the civil division, civil judge. Huh? Staff. Huh? In view of the above, the land council for the party submits that this writ petition has become infractuous. Okay. Accordingly, this writ petition is disposed of on becoming infractures. Okay. Then in this case, your prayer is
In view of order passed in the repetition manner, civil petition has also become.
No, Roshi, there are another prayer also.
no,
So during pendency of that appeal, land should not be mutilated.
so that is already there. There is a stay. It indicates only. It indicates stay.
That observation may kindly be made in the order also.
My lord, here, my lord, I have objection. My lord, they have not
Otherwise,
object to
Just a
the
minute.
acquisition process. That is, they are not objecting to the acquisition. Only difference between these two parties with regard to the award, which the authority is ready to pay. How, because of this dispute between them, the developmental process can be stalled, the mutation, or otherwise the rest of the acquisition process, other acquisition process will also become useless. My lord.
no, I am just saying that
My lord,
over the land
here in
under
the
dispute.
case of land acquisition, my lord, even if there is a dispute with regard to the quantum of compensation, apportionment, or anything, there is a provision for revision, reference. Even in that reference, the reference can continue, go on, but in such cases also, it is the acquisition process is never stalled, my lord.
That aspect, my lord, I will clarify, my lord.
My learned friend, this individual petition matter, request for district collector matter. He cannot make a submission before this court contradicting his own order.
I'm just objecting to the interim of,
In respect of the disputed land. So, my learned friend cannot contradict that.
that acquisition, only the award, final award has been kept in abeyance.
The individual petition may be closed matter in view of order passed in the matter. Repetition.
No, Lordship, some observation later. Had there been the acquisition process been carried out under section 40 subclause 1 of the Act, I would not have privy before this honorable court to hold the process, Lordship.
See, the land compensation, when they say that they are ready to pay the land compensation, then this restraint and by this order 21/5/2025, it has already been suspended acquisition.
But Lordship, the activities are going on, Lordship. So what I am submitting before this honorable court, as simple as Lordship.
If the activities are going on and against the order passed by them, then you see there is a separate course of actions.
Lordship, I don't have any objection over the activities carried out in the land where the compensation has been cleared, Lordship.
Land Council for the Civil Revision Petition also heard Mr. Mr. State is respondent number?
One.
Okay, Henrata, then additional AG for the respondent number
1.
1, and Mr. R. Sakya for respondent number 2 and 3. Start. In view of the order passed today in writ petition C 513/2024, this civil revision petition has become infructuous. Start.
Accordingly, same is disposed of, only.
No, Lordship, only in that case, Lordship, Deputy Commissioner has no authority to hold the compensation amount. It should be forwarded to the reference authority, Lordship. Amount should be transferred to the reference authority.
Now, see,
under section 77.
Probably have understood, and that is why they says that Captain Evans, the matter is amicably settled, and thereby also he is giving an opportunity to both the party to amicably settle before the civil judge senior division. Probably it won't take much time. So that way, this,
no, Lordship,
since till then this operates, this kept in abeyance operates, and against this, if they start any activities, then that will be a separate course of action. So you can file against that because they cannot go against their own order.
In fact, Lordship, there is no dispute over the judgment of 1996, Lordship. That is not being interpreted by any court of law, Lordship.
That is why now,
meaning thereby,
now they have understood how they have probably have understood. So what is the extent of their right, and then what is the extent of your right? So probably,
and Lordship, even Deputy Commissioner has passed the individual error under 37.
Here in this case, in the writ petition, they have challenged. Now they will take up there in the civil.
Even this individual error has not been challenged by any of the party, every party, Lordship. Since this order, individual error has been passed, considering that the land is in my favor, so there is no question about that the dispute is pending before the civil court, Lordship. So, award section 37 can be invoked only after all the formalities, procedures laid down in the section 21, 23 of the Act, Lordship.
Now see.
So these now crossing all those sections, section 37 has been arrived now, Lordship. So how Deputy Commissioner has installed the payment of disbursement of the amount even after arriving the section 37 of the Act? There is no any authority as per LARAC for the Deputy Commissioner to hold the compensation, hold the disbursement of compensation amount, Lordship. After passing this individual award under section 37,
you make an appropriate application before the civil judge In the meantime.
Lordship, the matter pending, matter referred to the civil judge is only with regard to the appeal filed by the respondent, not with regard to the compensation, Lordship. Now, compensation aspect is completely different from the civil proceeding, Lordship. This is under the law, Lordship, 2013 Act, Lordship. The Deputy Commissioner cannot revert the award after reaching the section 37 of
Now see,
the Act, Lordship.
The impugn order which you have challenged has been passed in that appeal only. You are connected to this case to that extent, and that is why you
No,
also
Lordship.
cannot go beyond.
In that case, Lordship, my respectful submission before this would be, Lordship, there is a certain procedures under the Act. Section 21.
That's why you raised
Section 21, in Section 21, they should have approached before this Honorable Court. After crossing the Section 21, after passing the Section 21, there is Section 22 where they can lodge a complaint, claim an objection. That section is over, Lordship. And considering the merit of the case, the Deputy Commissioner has reached up to the Section 37 and passed the individual award in my favor, Lordship. Even after passing the individual in my favor, they are installing the disbursement of the amount only, Lordship. That is the only question, Lordship. This shows the malafide intention of the Deputy Commissioner, Lordship.
No, if they are agreed by the non-disbursement, that is separate cause of action, what I am saying, because here you are confined with this impugn order which was passed in that appeal only, and that appeal has already been transferred. So that is why it has become.
Lordship, in my ground phase number 14 and 14, ground number 3 and
To
4.
make things very clear, my lord, there are two aspects of the matter. One is that earlier pending appeal, which after a KEBA decision appeal were made, and that was dispute is there, the appeal was pending. That is another thing. In the meantime, this acquisition process has come up, the compensation award has. Now, if at this stage, if the compensation award also is being made, if there is a dispute with regard to the ownership, whom to pay? In that event, it is the Deputy Commissioner who can send it for reference. Either it can be sent for reference under the LARA Act, or the appeal pending, that can be also decided by the Civil Judge Senior Division. In both ways. But authorities, in both cases, the Deputy Commissioner is the one to take the decision. Either he can take the decision under the LARA Act to refer it to the authority. That will be the district judge. So, if the appeal, that can be taken up by the senior judge, yes, Civil Judge Senior Division. That is the thing. In both cases, here in this case, the pending appeal has been sought to be decided, has sought to be transferred. He has done the right thing.
If anything comes beyond that, you just approach the appropriate court.
There in the Civil Judge Senior Division.
Including the High Court, because this is limited to that extent. Okay.
Lordship, in my ground phase number 14, 3 and 4 is very clear that.
Ground and ground you can take so many times. Okay. So accordingly, this civil revision petition stands disposed of. Okay.
Lordship, Deputy Commissioner may kindly be directed to adhere with the order passed by the.
No, automatically, you see, that is what I am saying. If you are aggrieved thereafter, beyond this, you have a liberty to approach the appropriate forum, including this High Court. What I am saying, that is why will be separate cause of action. So now here it's only you see you are challenging the impugn order, and which is regarding the appeal, which has been transferred. So now it's complied.
Deputy Commissioner may direct it to Lordship transfer the amount to the reference authority. Lordship. He cannot. He don't have any authority to hold the amount in which has passed in favor of me.
Before civil judge, you make a prayer. This prayer before the civil judge, it will be automatically transferred.
Deeply.
My lord, in this case, the accused is languishing in custody since last 43 days. It's a regular bail application under 483.
Hmm.
If my lord may have page number 22, that is the FIR. Primarily the FIR.
Yes.
Subject registration of FIR against so and so for impersonation, extortion, and other unlawful acts.
Okay. So this, who appears for the
Yes,
state?
Lordship. We received CD, Lordship. Here is the case where the contingency MTS impersonate the executive magistrate and collected amount of rupees 90.
Okay, the report was called for.
Yes, Lordship. CD is there, Lordship.
CD was called for. Okay.
Lordship, 37 victim has to be examined, Lordship. Examination is in process, Lordship.
What is the status of the case? Charge sheeted?
Not charge sheeted, Lordship.
Okay. Immediately after FIR, he has been arrested.
Investigation is going on, Lordship.
Investigation going on.
Yes, Lordship.
So
And there is a
As of today, my lord, it's 43 days.
40?
43 days. And
43
I'm bringing a ground that I'm a HIV patient, my lord. On that context, my lord, I'm praying for the consideration of bail, as well as considering the fact that I'm only 19 years of age, my lord. And I'm not I don't have any criminal incident as such. I'm a first-time offender. And I have acted on the direction of the Deputy Commissioner, my lord. If my lord, may go through the records, with all fairness, my lord, in this case, if the investigation is going into the right direction, it should be the Deputy Commissioner who should be arrested, my lord, not the present alleged accused, my lord. My lord, allow
Whether
me,
the
I'll just-
deputy commissioner has been examined?
no, Lordship.
Deputy commissioner.
Lordship, here issue is different, Lordship. They impersonate, they force the seal of executive magistrate and Lordship collected.
It is under the knowledge of the deputy commissioner, whether the deputy commissioner who has authorized.
So it's pertain to the Lordship, only IG Park, only Lordship. The authorization is only for the IG Park, but not in all the shop, Lordship. They forced the signature, they forced the seal and collected the money from the shopkeepers, Lordship. Kindly peruse the CD, Lordship. I flagged the operative portion, Lordship. Kindly peruse the CD. I've marked the operative, Lordship. There is material against the accused, Lordship.
As of today, my lord, it's 43 days. And the very purpose of investigation, my lord, is only to secure the presence of the accused before the trial court, my lord. Since last 43 days, I'm under custody, my lord. And I'm a college-going student. I'm pursuing second year.
Lordship, in CD, he is a contingency MTS, Lordship, not the college-going student, Lordship.
You justified from the records.
Okay, it's impersonation.
Yes, Lordship.
2 sections are available and 4 sections are non-available in this case.
He used the magistrate on duty.
Yes. Serial nameplate, Lordship, and collected money from the shopkeepers. Lordship, green flag is the says memo, Lordship. Money received from the shopkeepers, Lordship.
Okay, he has admitted.
Yes, Lordship. On Lordship, there's a 37 team has to be examined, Lordship. And there is a possibility of another co-accused, Lordship. So at this stage, granting bail will hamper the investigation, Lordship.
What the deputy commissioner has been, the statement of deputy commissioner has been recorded, no,
Not recorded, Lordship.
because he would be the person who would be knowing.
Since deputy commissioner is transferred
As to
to the Delhi, Lordship.
By me, madam.
now order to reflect that is HIV negative, not positive.
My lord, I have a medical report which I have obtained from the R Commission, my lord.
But
And
the order, how it has been reflected in the order passed by the.
my lord, that has been misread by the misread the records, my lord. There has been an erroneous finding on the part of the learned trial court below.
And if
with all
he is a
fairness.
positive, then his name shouldn't be taken.
My lord, if my lord may kindly have page number 32 for a time being of my petition, my lord. This is a report of laboratory test, my lord, of R Commission hospital. My lord, 3 tests were done. Final result, my lord. The result has been classified into 3 parts, my lord. Negative, HIV, HIV2. A tick mark has been given in HIV, my lord. Since the negative is down below the final result, that is the reason, my lord, there has been a misreading of record by the learned trial court below. That is my humble understanding, my lord.
Negative is.
Final result.
Negative result does not exclude the same exposure.
The final result has been classified into 3 parts, my lord. Negative, and the tick mark has been given in HIV, my lord. So therefore, my humble understanding is that there has been a misreading of the record and there has been wrong observation on the part of the learned trial court below in rejecting the bail on this count, my lord.
If he is a positive, his name should not be taken.
My lord.
If he is a positive, HIV positive,
Well,
his name should not be taken. His name should be.
if my lord
concealed.
may kindly have page number 29.
Hmm?
Page number 29, my lord. That is the green booklet, my lord. Green booklet are being usually issued to the
Page?
HIV patient, page number 29. Patient booklet, my lord, green booklet. These are being issued to the HIV patients, my lord. And this has been issued by the recognized medical institution, my lord, that is RK Mission Hospital. My lord, I'm at this moment, I am 19 years of age, my lord, and I have acted on the direction, on the basis of direction given by the deputy commissioner. Undoubtedly, my lord, prima facie, there is a case. I'm not denying that fact.
Yes.
But
Because you
whether,
yourself
whether my lord,
admitted also.
whether my lord, a further custodial interrogation is necessary or not, my presence is required only for the trial, my lord. Whether my further custodial interrogation is necessary or not, that is the reason, my lord. That apart, my lord, considering the fact that I am a HIV, there's every possibility, my lord, of getting infected, my lord, if I'm being kept into custody for a longer period of time with the other jail inmates, my lord. There's every risk for my life as well. And if my lord allows me, in respect of HIV patient, the consideration of bail, in fact, observed by the Honorable Supreme Court as well as our court, my lord allows me, I'll place those authorities, my lord. Only short judgments.
So what this court has observed, you said?
Considering the fact that he's a HIV patient, has given the benefit of bail, considering the fact that there's every possibility of getting infected inside the custody, my lord. Even the Supreme Court has made a certain observation on that count.
Outside, there is a more scope of spread.
In fact, my lord, he is not immune from getting infected,
Inside
my lord.
the special treatment, the jail authority.
My lord allows me, I'll just read the one paragraph, only one paragraph. Only one paragraph of the judgment. It's a very short judgment. My lord allows me. My lord may read if there are 3 and 4, my lord. This was decided, this judgment was passed on 2024 by the double bench.
No, which one? This is 22? 11/4/2022? Or which one? This one? Para 4?
Para 3 and 4. Supreme Court, my lord.
Which one?
Having regard to my.
Which one? 2024
Supreme
online. So online.
Supreme SC 750, my lord. Supreme Court judgment. First judgment which I have placed, my lord.
Yes.
Para 3, my lord.
Yes.
Having regard to.
Yes.
Having regard to the peculiar circumstances of the case, given that the petitioner is suffering from HIV and appears to be immunocompromised, this court is of the opinion that the case for grant of bail is made out. In the circumstances, the petitioner shall be enlarged on bail, subject to such terms and conditions imposed by the trial court. This is a very short judgment, my lord. Basing on the medical report, considering the fact that he is a HIV patient, the bail has been considered. Well, the second judgment of our own coordinate bench, my lord. Para 6 and 7.
Yes.
Para 6, man. I have considered the submission at the bar with circumspection. The health status report of the petitioner clearly reveals that the petitioner is immunocompromised and she is an HIV patient who is also suffering from tuberculosis. She is prone to infection as she is immunocompromised. She is lodged in a jail with several inmates. I have also considered the submission that trial has not commenced. The petitioner was behind bar since so and so. Charge sheet has been laid against the petitioner, but charge has not been framed and the trial has not yet commenced. I have also relied on the decision of the Honorable Supreme Court in Bhavani Singh's case. It is indeed trade law that in cases involving NDPS Act, especially involving in seizure of commercial quantity of contraband, the rigors of Section 37 are to be complied with. On the other hand, there are indeed provisions of Article 21 of the Constitution of India to say that life and liberty of the person are equally important. Considering all aspects in the light of the decision of the Honorable Supreme Court in Bhavani Singh's case, I deem it proper to grant bail to the petitioner. The petitioner is enlarged on bail with so and so, madam. And there is a latest judgment. Honorable I'll study with it, para 5, madam. As observed herein above, the accused person is indeed suffering from HIV, irrespective of the fact that the treatment given by the state may be adequate or not, as the case may be. This court is of the considered opinion that to the accused to get proper treatment or recuperate from her suffering in an environment congenial to her. Needless to say, grant of investigation criminal proceeding would be served. Upon the certain consideration, the prayer of the petitioner herein is allowed. The accused person so and so is directed to be enlarged on bail on the following conditions, my lord. Considering all those facts, my lord, being a HIV patient, and I'm only 19 years of age, my lord, and I've been languishing in custody since last 43 days. Well, prima facie, there is a case, my lord. I understand that. But whether a further custody is required, my lord, there is no flight risk, my lord. I'm a bona fide of this place, my lord. There's no flight risk also, my lord. Considering that aspect, some leniency, my lord, I'm seeking.
Your bail application was rejected recently only.
My lord?
Bail application was rejected recently only.
Yes, my lord. The next step, my lord. Page number 15, my lord. Page number 17, my lord. Fifteen 7/2025.
Yeah. But there is a prima facie case against him.
My lord, admittedly, prima facie.
And then the corroborative evidence,
Right.
the witnesses also stated clearly.
Yes, my lord. Prima facie, there is a case.
Then another circumstances you see.
Lordship, in page number 17, Lordship, the last para also it is written in the bail rejection order, Lordship. The accused is a HIV negative as per the medical report submitted by the IO, Lordship. So the document submitted by the petitioner is also, Lordship, doubtful, Lordship. So if it's so, Lordship, board may be constituted, Lordship, to examine the accused, Lordship. In the bail rejection, Lordship.
That is the reason there.
Whether the same these documents were
Furnished to the IO, my lord.
furnished to the.
There was a misreading of the record, my lord. Those three parts.
No, because this report, what you have submitted,
My lord.
is clear, but then the observation made here by the trial court is different again. It says negative. Although you have claimed that HIV positive, but the report says that HIV negative, it says.
Yes, sir.
In that case, your only ground for seeking bail is that he is a HIV positive.
My lord,
would be
my ground would be
difficult.
on two different parts, my lord. Being considering the fact that I'm only 19 years of age, my lord. I'm a first time offender. I have no any criminal antecedent, my lord.
19 years
And
you are only 19 years.
19 years, my lord. And I have acted on the basis of the direction given by someone who has not been arrested till today, my lord. I have acted on the basis of the direction given by someone, my lord. If my lord can peruse, my lord, those I have enclosed 3-4 orders given by the deputy commissioner to act. I have acted accordingly.
No, that's why I was asking whether the statement of the deputy commissioner has been read.
Not recorded since the dip
Now,
If that is so, my lord, then my lord may kindly direct the IO to submit a medical report basing on which they are relying, my lord. Because I am submitting a medical document from a very recognized institution, my lord. That is RK Mission. And
in the meantime, because this is his statement, because he is based on two things.
Yeah.
One, this certificate.
Yes.
That he is HIV positive.
Yes.
The other, he has acted on the basis of the order and instruction of the Deputy Commissioner. So now his statement is crucial.
Lordship, this order was for patrolling Capitan region only.
That is there, but the statement is necessary because his claim is that he has acted on the basis of this and what instruction he has given and what the Deputy Commissioner said. He acted, accessed the order. Order was limited to that and he exceeded. He might state. So,
but Lordship, the patrolling and this illegal collection of this is different, Lordship, from this
yeah,
order.
that is what I'm
Lordship.
saying. That is what I'm saying. His statement is crucial
Yes, Lordship.
because he is basing on
That's true, Lordship. The statement of the Deputy Commissioner.
So
in that case, my lord, may kindly.
So what I'll do is because this order, this court has no reason to disbelieve the order passed by the magistrate also.
My lord.
So you
Before my lord.
obtain
Why may I suggest, my lord?
through IO
My
a
lord.
copy of the document which was based on for filing bail application before the magistrate and or the authenticity of the certificate produced by the petitioner. Okay, there is a certificate.
Yes.
That he is HIV positive. That, okay. And also if possible, telephonically, virtual, whatever may be, try to record by way of preliminary inquiry also, but then record a statement of the Deputy Commissioner if he is available. Yes. Because he basing on the Deputy Commissioner's order, and then probably he might have been instructed with us. The other officers also sometime or in a time, the other officers are also designated as magistrates. So he has used magistrate on duty. I don't know. But then the statement of the Deputy Commissioner is crucial. Okay. Okay.
My lord, since I'm heavily relying on the report part, my lord, HIV positive and negative. Since they are disputing that, my lord, a simple direction may kindly be given to bring on record, basing on which they have made a statement before the learned magistrate stating that it's a HIV negative, my lord. That record may be called for.
Mr. J. Siru, Land Council for the petition. Mr. Loy, Land PP. Also have Mr. Loy, Land PP staff. The order of the magistrate passed on. The rejection or of the rejection of the bail filed by the petitioner before the magistrate reflect that the accused was
That's okay. I need to get the prints or the
reflect that the accused is HIV negative. However, the count he has annexed the patient. You have submitted the patient booklet.
My lord. Patient booklet.
Oh, sorry. He has submitted the laboratory report and patient booklet, green booklet, within bracket green booklet.
As well as laboratory report.
As well as?
Laboratory report.
Which?
Page number 32.
Okay. As well as yes, laboratory report. Submitted the patient booklet, within bracket green booklet, as well as the laboratory report, wherein it is reflected that the accused is HIV positive patient. the petitioner also the claim of the petitioner also is based on the order of the deputy commissioner that he was authorized and he acted being authorized by the deputy commissioner, the then deputy commissioner of ICR. So in view of the above, Mr. Lloyd shall obtain instruction regarding the authenticity of the patient booklet, green booklet, and the laboratory report of the accused. And also the statement of the deputy commissioner and submit the same along with the case diary on the next stage. Okay.
Second week of Lordship. Second week of August. Be it on 4th, Lordship.
4th
On 4th.
4th.
Yes.
Okay. List this matter again on 4th, on which that the PP shall produce the updated CD. Okay.
Grateful.
Grateful.
PP. Okay, so the record has been received. So then this can be listed for admission. Okay? Yes. Since sorry, hard miss Giri, no? The counsel for the petitioner. Also Mr. G. Tado for the state, sorry, G. Tado additional PP for the state, and you're for private respondent. Yes. Okay, Miss.
Legal
Mr.
Aid Council.
Mr. Huh?
K. Tama. Legal Aid Council. It's a Legal Aid Council.
Legal Aid Council, okay. He is not present today.
On his behalf.
Mr.
Yes, I'm on behalf of K.
Oh, you are okay. Mr. Huh? Appearing on behalf of Mr. K. Tama, Legal Aid Council for the private respondent. Oh, sorry. The trial court record. The scanned copy of the trial court record has also been received. Since the parties are present and the record has also been received, let the matter be listed for admission after 3 weeks.
Please, my lord. My lords, in this petition, I'm challenging an order of the trial court, rejecting my application seeking deletion from the suit. On the last date, my lord, we had submitted that the trial court failed to consider the materials on record. The Honorable Court accordingly called for the records of the trial court and directed me to take steps for service. I have taken the steps for service. The service report is still awaited, and there's one small inadvertent error in the last order, my lord, in the name of the trial court. So instead of on the last page, my lord, instead of the Special Judge Senior Division UPR District Court, it may be corrected to Civil Judge Senior Division UPR District Court, and the records may be called for.
Okay. Record was not yet called for.
Record was called on the last date hearing. It has not received, and the service report is still awaiting.
Okay.
So this may be corrected to Senior Civil Judge Senior Division.
Just counsel for Mr. You are Mr.
Tejpal Singh Rathod.
Line counsel for the petitioner. H.K.
Tejpal Singh Rathod.
Tejpal Singh Rathod.
Please, ma'am. Tejpal Singh Rathod.
Okay. Mr. Tejpal or Mr. Tejpal Singh Rathod, line counsel for the petitioner. steps. How many respondents are there?
My lords, there are 8 respondents. Respondent 2 to 8 are pro forma parties.
Okay.
Respondent 1 is the
Some
contesting.
is like it's taken steps upon all the respondents. However, the same is still awaited. Now the return service, it is still awaited. The planning council for the petition summary step. The record is now by an order dated 2/7/2025. The record of the trial court record was called for from the Court of Special called for. However, there is a typographical error in the authority, which is written as Court of Special Judge Senior Division UPR, and praise for correcting the same as Civil Judge Senior Division.
Civil Judge Senior Division.
Civil Judge Senior Division UPR.
Records may be called from Civil Judge Senior Division.
The same stands corrected. Okay. Stop. Let the record be called for from the Civil Judge Senior Division UPR of Mubarak District, Arunachal Pradesh. Okay. List this matter after 3 weeks.
My lords, I have traveled from Delhi, my lord.
When?
If convenient, if a date may be given, September 8 or September 15, whenever September 8 or September 15.
By the Land Council for the petitioner, let this matter be listed again on
September 8.
8 September.
And on the last date was recorded, the interim may be considered on the next date. The interim may be considered on the next date, my lord. It was recorded in the
interim will be considered on
the next.
Okay. On which date the interim prayer shall be considered? Okay.
Please, grateful, my lord.
I was seeking for adjournment.
Okay. So trial court record have received. Okay. So respondents are present.
Lordship, I am appearing on behalf of T. Taba.
You are appearing for the first time.
No, Lordship. I'm the party here.
Item number 17 is appearing, madam.
Yes.
16, he is appearing.
Yes.
No, who is for the petitioner in 16?
Yes, ma'am.
You are for the petitioner.
On behalf of the Tapak.
Okay, Mr. You are Mr.
K.N. Tatik.
Mr. K.N.
Tatik.
Land Council appearing on behalf of Mr. P. Tapa, Land Council for the petitioner. Your name is not there. Have you filed Wakalat Nama?
I'm not appearing, Lordship. Senior has instructed me to appear.
Instructed you to appear. Okay. Who is your senior?
T. Taba.
Okay, and Mr. Etes present, huh? Also had Mr. Etel and additional PP, huh? So Miss
N.
And N and would appear on behalf of our senior. Who is your senior?
T. Taba.
T.
Taba. In item number 17, I'm.
No. In 16?
They are the petitioner. I'm appearing for the first time, Your Lordship.
That is what I'm saying.
Yes.
Okay.
On behalf of T. Taba.
Here also, no. Here, T. Tapak. Tapak is a petitioner here in 16.
Yes, item number 16, my lord, he's appearing on behalf of T. Tapak. In item number 16, she's appearing on behalf of T. Taba.
Oh, Taba?
Taba, yes.
Sorry.
Tito Taba.
Appearing on behalf of Mr. T. Taba. Taba, huh? Learned counsel for the respondent number?
Petitioners, both are petitioners.
No, 16. 16, respondent number?
You have responded.
Private respondent.
2.
Yes.
Okay, respondent number 2. Can press for some time to file wakalat nama, prayer allowed. List is matter after 3 weeks.
Can it be after a week?
Your
After
lordship,
a week.
let's it be after a week, because your lordship will see in item number 16, it's a bench order. It matter has been actually mentioned before this court and it is listed.
Okay, after a week. Okay. Then in 17?
Both the matter will come up together, my lord. It's a connected matter.
Okay. Okay, after a week.
Item number 7, please.
Then after that, the interim of criminal petition number 31, 2024 shall continue till the next date of listing. Okay.
Obliged, madam.
Obliged.
Lordship, may I? Lordship, is the quashing petition filed by the complainant and the alleged accused person? They have jointly filed the quashing petition for the quashing of the FIR and the charge sheet. Moreover, they came to the amicable settlement.
Husband, wife, my lord.
Husband and wife.
Husband and wife?
Yes.
Have received the
Your lordship, perhaps this year has been
file for received.
received, my lord, perhaps. Not received. Not received.
What is the offense involved?
Yes, Lordship is registered under section 323 and 498A. Moreover, they are came to be amicable settlement along with their family member. They settled the matter amicably.
Settle the matter?
Yes.
Proceeding is state.
Where is the settlement?
Page 56.
Page 56.
So do we know the status of the case?
My lord, this matter was stayed on 24/4/25, and they have annexed the order of the Lanet Trial Court, which is annexed in page number 55. Your lordship, the matter was fixed for CC, my lord. And it was
is there any stay?
Yes, your lord, it was stayed. Further proceeding has been stayed, my lord, on
Okay.
24/4 to 2025, my lord.
Okay, so
And your lordship, the charge will framed under 498A and 323 and the same section. So, my lord, perhaps the records are not required because it is state and admittedly they are husband-wife, my lord. Because if they are not husband-wife, 498A will not be attracted. So, if since the charge has been framed under 498A and 323 is a compoundable offense. So, my lord, since they have entered into a settlement, your lordship, the state has no any objection if the matter is interfered by this honorable court.
So metal will dispose of the matter.
Yes, your lordship.
Okay. Hard, Mr.
M. Tanga.
M.
Tanga. TNG.
Tanga, line counsel for the petitioner. I've also heard Mr. T. Line additional PP. So just a minute, sir. This is joint petition only?
Yes, your lordship, joint.
FIR is in page 13, my lord.
Okay, this is a joint petition filed by the petitioners under section 4, 5 to 8 of the Bharatiya Nagrik Suraksha Sanhita 2023 for quashing of criminal proceeding in Itanagar Government PS case number 20/13 under section 498 within bracket capital A /326 of the Indian Penal Code 1816 pending in the court of the Chief Judiciary This is proceeding, quashing of the criminal proceeding in GR, GR case number, GR number 28313, arising out of Itanagar PS case. There will come. Okay. The petitioner number 1, the petitioner number 1, Srimati Meena Bagam is the informant, and the petitioner number 2, Sri Baba Bagam, is the accused in the above mentioned police station case. Okay. Where is FIR?
Page 13, my lord.
I'll just mark the, and then order will be passed inside. FIR is at
Page 13, my lord. Annexer 1. Page 13.
Is FIR. Charge sheet.
Charge sheet, my lord, is in page 14, my lord. But your lordship, the type, the operating portion would be page 19 to 20.
20, okay.
19 and 20.
Okay, then CC,
And
order, they have annexed.
Yes, your lordship. CC is in page 55, Annexer 3.
55.
Yes, ma'am. Although in FIR there is an allegation against the firing of the pistol, but your lordship, nothing, no section has been registered under Arms Act, and not been charge sheeted under Arms Act, and not been framed under Arms Act.
Okay.
And the settlement is in page 56 and 57, Annexer 4.
Agreement page 56.
Yes, your lordship.
Okay. So I'll dispose of.
Obliged.
I'll dispose of them.
Well, item number 19 is an IA for impleading the informant, impleading the complainant, who is also the IO, as a respondent in main revision.
In revision,
This is 26.
yes, your lordship has already passed the order, your lordship, in the revision. The proceeding was stayed. Your lordship, there, your lordship, the complainant, the de facto complainant has not been impleaded, so they have filed an IA. So IA may be allowed and direct them to take steps on complainant.
Mr. Okay. Mr. Tungun, R.L. Tungun, non-counsel for the applicant. The applicant filed criminal revision petition number 26/2025 before this court, where the informant was not included as respondent party. By filing this application, the petitioner prays for including of the informant,
Complainant.
Here your
Complainant,
lordship.
and he is also the IO.
Complainant is the respondent.
Number 6.
Number 6 in the criminal revision petition 26 AP 2025. The prayer not being objected. Sorry, the Lana additional PP has no objection. Accordingly, the prayer is allowed. The Sri Geba Jini.
No, my lord.
Who is the informant?
To go come that page 5, my lord.
Okay.
Page 5, 6.
Okay. According to Sri Tubo Kamdak, ASI Alo Police Station, District West Siang, Arunachal Pradesh, be impleaded as respondent number six to the criminal legal petition number 26, AP 2025. So with the above this, IS stands disposed of, okay? And in the main,
In main case, Your Lordship, TCR was called for, Your Lordship.
okay. In the main, in view of the order passed today in IA criminal number 78, AP 2025, Mr. Sam is implemented as respondent number 6 staff. The issue notice to the newly implemented. In respect of other, you have already taken steps or implemented respondent number 6. The petitioner shall take steps by a registered post with AD as well as by usual process upon the respondent numbers, newly implemented respondent number 6 within
A week.
within
Within a week.
within a week from today start. List this matter. When?
After 2 weeks, madam.
After 3 weeks. Okay.
Obliged.
Interim order may be continued.
There is interim.
Yes,
Yes, the interim order passed earlier shall continue till the next day of listing. Okay.
Obliged.
Item number 20, 21, and 22 are analogous method, connected method also.
Okay.
I've taken a step upon respondent number 3, 4, 5, 6, and 7.
Yes, 3 to 7. Not yet. Yes, received.
Lordship, on the last occasion, TCR was called for, but in the order it was not reflected, Lordship.
Not reflected?
Yes, Lordship. I think it's my.
Okay. Mr. Ingo, huh? Ingo, Learning Counsel for the petitioner. Also, Mr. Loy, Learner PP, huh? Staff, huh? The office note dated 25/7/2025 reflect that the notice upon the respondent number 3 to 7 is still awaited. The counsel for the party submits that the trial court record will be necessary for proper disposal of proper adjudication of the matter. Accordingly,
Lordship, there was observation of this honorable court last time.
There already.
Lordship, yes, learned PP was submitting for that, but however, the learned court, honorable court has considered view that since I have a petitioner has already annexed the certified copy of all the records, so it is not required. That was the observation made by this honorable.
Not necessary.
Yes, that was the observation made by this honorable court. Since I have annexed all the documents certified by the court itself, Lordship.
Still, you want the record?
Even
If it's a Lordship, then
No, the
yes.
whether the proceeding was has been stayed.
Yes, Lordship,
Yes.
proceeding on the state. All the original records were annexed, certified by the.
How? Oh, it's certified. Still, if you want, we can call for the scan copy.
Lordship, if he annexed all the documents, then I think
Not required.
Not required.
Okay,
Lordship.
then in that
Yes,
case,
yes.
okay. In view of the above, this matter after 3 weeks.
Interim may be continued.
You have annexed entire charge sheet
Lordship,
and proceeding thereafter before the court also.
Lordship. Even if this honorable court desire to perish the record, may kindly call.
No, so the court has only observed that Mr. Loy submitted for calling of the record. So record not necessary, I haven't seen. No, my God. Okay, for his satisfaction, let us call for the same copy of the record.
Yes, Mr.
Sometime it happened that you might have forgotten to annex some of the document.
Yes, in that lordship name.
Okay. You submitted that. The trial court record would be necessary for proper adjudication of the case. So in view of the above, call for the trial court, scanned copy of the trial court record. Okay, list is made after 3 weeks.
Lordship interim is the interim kind.
Stop. The interim order passed earlier shall continue till the next date of this thing.
And item number 21, 22, same.
Same.
Connected.
Okay.
Connected.
Deeply obliged.
Deeply obliged.
Lordship, before I was seeking for adjournment on behalf of Mr. Titopu.
Yes, yes. Orders are communicated. It was communicated. Who appeared for criminal petition? Yes, Mr. You appeared earlier. Yes, ma'am. Yes, Gary was called for. Yes, my lord. Joint petition. Joint petition. Charge sheet has been still under investigation or charge sheet filed. CD was called for, but matter has been charge sheeted, and the offences under which the initially the FIR was registered on the same sections the matter has been charge sheeted. And your lordship, there is an order from the coordinate bench. Order is there. Your lordship will find there. Your lordship, the observation was given. Your lordship, because it's involved a girl who has been engaged in some work and which has not been sufficiently paid by the owner. There are serious allegations, my lord. These are the subject matter of this case. But since now they are praying for adjournment, your lordship. And your lordship, since your lordship, the charge sheet matter is culminated into charge sheet, TCR may be called for. Yes, your lord. Scan copy of the TCR. Okay. Mr.
T. Takyang?
Tachang, your name is not there?
No, your no, Lord.
You are appearing on behalf of?
Titopu.
Appearing on behalf of Mr. Titopu. Mr. T.H.F. Lanak, additional PP, public prosecutor for the state of Arunachal Pradesh, Assam State. So during the pendency, only charge is submitted. Yes, my lord, on charge sheet was filed on 23/7. My lord, this is the intimation letter from the IO. Okay. During the pendency of this petition, the case has already been submitted into charge sheet before charge sheet. Therefore, the record may be called for. Okay. Call for from the which CGM? Yes, my lord. This is Itanagar. Yes, your lordship. Itanagar. Yes, the CGM, your lordship. Chief Judicial Magistrate. Call for from the concerned court. Stop. Okay. Call for. Then in that case, number, this is number. Number not yet numbered. Yes, your lordship. So In view of the above, the registry shall call for.
Your GR number is, your lordship, in the GR number is
there?
359 of 25. Your lordship, in there.
Okay, then in that case, so call for.
GR number 350. Your lordship will find in page 2.
Trial code record of GR number
359 of 25.
359 of 2025 from the Chief Judicial Magistrate UPR. Okay.
Yes, sir.
List this matter after
2 weeks, Lordship.
after 2 weeks. After 2 weeks. Okay. List this matter after 2 weeks.
Oblige, your lord.
Oblige.
This is unlisted.
My lord, here I have a serious objection, my lord.
There is. I thought this is a new.
No, this is not a new. This is the issue, your lordship. Will finally on last occasion, your lordship, the coordinate bench has directed them to file an affidavit to bring into the record your lordship, deposition of the victim, my lord. Your lordship will kindly find your lordship order dated 21/7/25, my lord. 21/7/25. Here is clearly said, Harti the Rigia, learned counsel for the applicant, also Harti the learned additional PP for the state, and Mr. N. Soki, learned counsel for respondent number 2. In this case, the trial court is here to examine the victim. The present bail application shall be considered after going through the evidence of the victim. Therefore, the petitioner shall file a certified copy of the evidence of the victim girl, and after that, the bail application shall be listed for admission. Now, they are listing, your lordship, in presence of this order, your lordship, they are mentioning the matter for urgent listing, man.
So where is?
They have not filed any affidavit, man.
No, you have to file an affidavit.
Yes.
Annexing the
My lord,
examination, the evidence of the victim. Thereafter, only.
yeah, my lord, if this honorable court allow me, I would like to submit. My lord, this bail application was pending for since long, before vacation only. And suddenly it was came after 21 of this month at the court one. So I was not being prepared. So matter was listed. And thing is that, my lord, this case, Honorable Special Court, Session Court, it was fixed the matter on the 17th to be record victim statement. Again, victim statement was not recorded. Again, it was fixed on 19. It was not as per course list, it was supposed to be listed on 19, but it was not listed. But as per the, there is
See, Mr. Riga. See, order 18/6/2025.
It is true. It is true.
So there also, it was to be listed after that. The victim was to be.
My lord.
The statement of the evidence of the victim was to be recorded on 16.
Yes.
This
My lord
order says that to be listed after 16, and then it was not recorded. Therefore, this court passed clear order. That
that's why, my lord, I'm coming to the point that.
Now, just you one thing you just tell me whether the victim has been examined.
Victim was supposed to be examined on 16.
Not examined. No.
As per statute.
Let the examination of the victim.
No, that's why.
Evidence.
That's why, my lord, it is
now,
the
challenge this.
Procedural lapse, illegality, because as per this, the POCSO Act, it said clearly stated, strictly clearly stated, section 35, sub clause 1, it is said that within 30 days, the victim statement should be recorded. And victim was called repeatedly, once again, repeatedly called. As per this POCSO Act, it is clearly said that victim cannot be called twice, thrice, only once only.
Now you file affidavit. You
yes.
challenge that if you are read the act of the court or for,
It is in the, my lord, here, section 35. Here clearly stated that. May I please read? Section 35.
Yes.
Here said that period for recording of evidence of challenge, dispose the case. Evidence of challenge shall be recorded within the period of the 30 days of the special court taking cognizance. Reason for delay, if any, shall be recorded by special court. The court has, the Honorable Special Court has not given any reason why it was delayed. Why it should be written in.
We have not seen that.
As per Article 21, that is the, the personal liberty of the accused.
See, you said that the evidence of the victim was partially recorded. We
Yes.
have not seen that order. While recording, the order sheet must have reflected why it was not completed. You have to file by your affidavit.
So, my lord, maybe fix day after tomorrow, I'll file affidavit.
Yes, my lord, my brother is referring to the section, but I will, your lordship, I will apprise the settled law. What
Even if
Supreme
that
Court
is-
says, my lord. In the event, if there is an undue delay, that too not on the part of the accused, then in such case, court may give a direction for release of the accused on the ground that the right of the accused for speedy trial has been infringed. That is the law, my lord.
That's why
So now, for that, without perusing the record, without relying on the record, because of whom the trial has been delayed, my lord, how they can come all of a sudden with the provision of the POXO Act, all of a sudden mentioning the matter, all of a sudden praying for filing an affidavit.
You have to give notice to the special PP also. But that also you did not do. They will not know.
I have already given notice. This is a pending case only, the bail
Pending
application.
case, you see that there is a clear order.
Yes.
If you are agreed with this order, you challenge this order. There is a clear order. You file appeal. If you are agreed by this.
Yes, your lordship. Your lordship, let them direct to comply with the order of 21/7/25, my lord. The last order. Because your lordship, after perusal of the record only, the court find it necessary to peruse the deposition of the witness or victim, my lord. And then, your lordship, their bail will be considered.
This matter has been listed on mention by the Land Council for Application. By an order dated 21/7/2025, this court directed that this matter may be listed, directed for listing this matter after recording of evidence of the victim girl. However, the Land Council for the petitioner submits that the victim has not yet been recorded. The evidence of the victim is yet to be recorded in view of the above. So what some observation has to be made against him only.
Yes, your lordship.
See, automatically it leads.
Otherwise,
Observation is to be made against you only. What do I do? See, what order need to be passed here?
Yes, it's a very clear, man.
It's clear only.
No,
To be passed.
my lord, again and again they are fixing date and delaying tactic and not informing the
Okay,
what
you
ground
filed
of.
against this order. See, there is a procedure in the court which you have to follow. We are bound. Everyone. You cannot apply your own logic in the court.
Yes.
Please forget about it. So we'll not make any observation.
Yes,
because
yes.
if I pass that order,
Okay.
it will goes against him only.
Okay, your lordship.
Okay.
No, any order need to be passed in.
will not pass any order. The order is clear, okay?
Yes, Your
If
Lordship.
any order is to be passed, because why it was listed, it will go against you. It's better for you.
Oblige. Much obliged.
This is in the item, minimum return and that place. Keep it there.